Good morning, everyone. Good morning. Welcome to this is the 4th annual Indian Law and History lecture here at Maine Law. For those of you who don't know me, I'm Professor Anthony Maffa. I have the honor of serving on the steering committee as the faculty member for this particular lecture. I want to thank everyone who's in this room and on the Zoom and who isn't able to attend today for whatever reason, for their support for this important Indian law programming at Maine Law, and especially the sponsors of this event, Drummond Woodsum, Elliottsville Foundation, the Trust for Public Land, Maine Conservation Voters, First Flight, and the Presumpscot Regional Land Trust. This year's lecture is titled Landback and the Law, and will be jointly delivered by Professor Monte Mills and Dr. Suzanne Greenlaw. Their remarks will be followed by a brief panel and question and answer about an ongoing private effort to return some 30,000 acres of land near Katahdin to the Penobscot Nation. Professor Monte Mills will speak first. He is the director of the Native American Law Center at the University of Washington School of Law. He is one of the Legal Academy's leading voices on natural resources and federal Indian law. And prior to academia, Monte was the director of the legal department for the Southern Ute Indian tribe in Colorado. So Monte, the podium is yours.
Well, thank you so much, Professor Maffa. I've really enjoyed my time here. It's my first time in Maine, so I'm grateful to have made the trip and make all the great connections. Also want to thank friends at Drummond Woodsum for their hospitality, hosting us yesterday, and letting me crash their federal Indian law class last night. So thanks to the students who were there as well. And then also really especially want to thank the NALSA crew here at Maine Law, Cheyenne and Holly, and others who so graciously hosted us for dinner last night. And last but not least, a special shout out to someone who I haven't seen in a very long time, but Judge Jill Tompkins is here. She was my Indian law clinic professor back in law school. So glad to see you again. So we are going to talk about Landback and the law. And as I was preparing, I've been thinking a lot about how to start these remarks. And I decided that probably the best way to do it would be not by me starting at all, but instead by starting with a short clip from a television show. And I don't know how many people are familiar with the show Reservation Dogs, but there is a short piece of that show that is about Landback. And I think it raises a few issues that might be relevant for our purposes today. So without further ado, Reservation Dogs.
What do you suppose that means?
What, honey?
You see the graffiti on that sign back there?
Oh, yeah. I think it said Landback, didn't it?
Well, what do you suppose it means?
Well, I reckon the Indians did it.
Well, sure they did. But I don't understand. They mean the whole damn thing? They want the whole damn thing back?
Well, I suppose so.
That's just not possible. I could see some of it back. You reckon that's what they mean, some of it back? Or all the damn thing?
I mean, the whites did kill an awful lot of them and took the land. So America ought to be ashamed of itself.
Well, they got the casinos. I hear they get paid $1,000 a month just to be an Indian.
Will you quit being a shit ass?
Well, that's romantic.
This ride is not fun anymore, and no, they don't. And whatever they get, they deserve.
Well, let's not get into a political discussion here. Let's just enjoy the Sunday drive.
You know, I am part Indian.
Yeah, and I'm part millionaire.
Yeah, you wish.
So, for those of you, apologies
No one
for the
believed it at
colorful
first,
language.
but now everyone wants one.
Reservation Dog. Sorry. And you can buy a nice knife too. Apologies for the colorful language, but for those of you who are familiar with the show, you will know that that has started, it coined a new term in our lexicon, and I encourage you to use it as you see fit. As I mentioned, I think in addition to a bit of entertainment, it raises some interesting questions for us to think about. What does Landback mean? What does it refer to in terms of scope? Are we talking about all of it or just some of it? And for our purposes, I'm going to focus a little bit more directly on the legal implications, the law and policy around Landback. And that's going to focus much more broadly, I think, than our other speakers as we move forward, which will have much more of a local context and certainly project-based application. A little bit more focused, I think, on private law opportunities for Landback. But for my purposes, I wanted to give just a bit of a overview and kind of big picture scope about the discussions around Landback that are happening across the country. So we'll do that in a couple of different ways. I want to just give a bit of history, maybe some context. I hope folks in the room are mostly familiar with some of the things I'll talk about there. But to the extent folks aren't, just want to frame up what we're talking about in the context of Landback and the law. Really, as much as anything else, I think these questions are about operationalizing Landback, like what in the legal structure presents opportunities or potential to pursue from time immemorial. All of the lands and resources of the continent were occupied, stewarded, possessed, engaged with by indigenous peoples. And for folks who aren't familiar with this particular project, but notwithstanding this historical connection, I think it's also worth recognizing that the law has had a particular approach to those connections, those indigenous connections with lands and natural resources. And just a few examples here that I think highlight the way in which the legal framework of the United States, at least, has approached land and property rights. And for law students in the room, I apologize that Johnson versus McIntosh is on the screen. I'm sure you've seen it repeatedly in your legal careers, but you're going to see it again because I think it is important to understand and recognize that the foundations of property law within this country are rooted in a particular conception about land and property. And as represented in part here, some of the justification for that framework is not really about justice or about certainly not recognizing indigenous relationships to that land, but rather sort of just an acceptance of prior European colonial theories, that those are the laws that have been asserted and sustained, and therefore they are the law of the land, even if, in Chief Justice Marshall's words here, it is an extravagant pretension to even assume that that should be the rule. So that's one way in which I think we can think about the legal framework sort of denying or rejecting the indigenous connections to land and premising a whole new system of property based on entirely different values. Fast forward a little ways to the heart of the allotment era, and even those agreements deemed the supreme law of the land under the United States Constitution, treaties, which continued a longstanding pre-colonial practice of nation-to-nation engagement, sovereign-to-sovereign agreements, the protection of lands and resources, at least as a constitutional matter, by the United States for indigenous peoples, the United States Supreme Court recognizing or determining in the early 1900s that even those promises were subject to an overriding power on the part of the United States Congress that could unilaterally abrogate them and therefore access and further compromise the integrity of indigenous land bases that had been reserved through those treaties in the century or so prior. And this recognition, this justification for that framework goes even further to excuse congressional action to say that the courts aren't even going to question when Congress does so because they deem it in both the Indians' best interest and the nation's best interest to exercise that power of abrogation. The legal framework, therefore, also, I think, in some ways represents the broader societal or cultural narrative. This, for folks who aren't familiar, is a painting by John Gass called American Progress, which I think they say is worth 1,000 words, but captures, I think, the kind of societal framework around manifest destiny, particularly in these times, and the understanding or belief, the sort of values on which some of these legal frameworks were built. And as much as anything else, as we think about the practice of land back or the values or connections or understanding of land back, you can see visually represented here the different values or understandings or connections or relationships to the land and resources that are represented between folks on one side of the screen and folks on the other. Now, that's not to say that it was just the cession of lands outside of reservation boundaries, but certainly during the depths of the allotment and assimilation era in the late 1800s and early 1900s, it was also about access to land and resources within those reserved areas. And in many places, opening up reservations for sale to non-Indians was not just allowed, but encouraged in terms of the acquisition of more territory. And the effects of that, this is the Confederated Salish and Kootenai, the Flathead Reservation in northwestern Montana, were to further disintegrate the territorial integrity of tribal land bases, even within reservation boundaries. The green lands here are retained tribal trust lands. The white lands are non-Indian owned surplus lands that were settled during the Homestead era. And the orange lands there were allotments made to individual Indian families. These gray lands are state trust lands scattered throughout the reservation. We'll come back to that. We'll actually come back to the story of the Flathead Reservation here in Montana, because it's illustrative, I think, of some other strategies that tribes have pursued about land back. And I think importantly here, right, this highlights not just the challenges in terms of thinking about land back as restoring connections to historical or sometimes referred to as ancestral territories, but we can also think about restoring connection, ownership, control, jurisdictional authority to lands within reservation boundaries in many of these places. And land back therefore encompasses sort of both on reservation, off reservation, tribal control, governmental authority, and some of those historical connections or treaty reserved rights that tribes may think about extending well beyond their current home bases. It's also important, I think, at this point to recognize that the impacts of federal Indian policy, and I would say especially during this period of allotment and assimilation, go well beyond land bases. And the efforts of the United States to break up land bases were also reflected in specific and determined and purposeful efforts of the United States to destroy tribal families, to destroy tribal cultures, to destroy tribal communities, to destroy tribal governments. The entire weight of the United States sort of focused on during this period, the elimination and disappearance of indigenous peoples. And that, I think, is also important context as we think about land back. It is not just about the land, but it is about the restoration of many of the things that come with the land, all of those relations that have been fractured, weakened, targeted by this history of federal Indian policy. And lest you think it's just historical, we can bring things forward to the modern times and some of the ways in which the law continues to frustrate or challenge efforts to restore or reconnect or invigorate those indigenous connections. This is from an opinion in 2005. Folks may be familiar with the City of Sherrill case. It's a case in which the Oneida Nation had repurchased lands within their original homelands, lands that had never been legally taken. The Supreme Court had actually acknowledged that they had never been legally taken because the treaties that were negotiated were not authorized by the United States, but only the state. And once those lands were repurchased by the Oneida Indian Nation, they said, well, we never legally lost title, so we are reasserting our sovereign rights to these lands, free from state authority, free from state taxation. And you can see that, unfortunately, at least before the United States Supreme Court, in an opinion written by Justice Ginsburg, the court said, you waited too long. And for you to assert those sovereign rights now would be too disruptive to the settled expectations of the non-Indian citizens of these areas of New York. And so not just historical sort of active efforts to destroy these connections, but in the modern times, I think the concern from the legal perspective about the reliance interests that have been established based on those historical policies and the disruptive effect of restoring indigenous sovereignty, restoring indigenous control and relationship have also been the basis for some of the challenges around those efforts by tribal nations across the country. So that's background and context, I think that really brings us up to hopefully thinking about the kind of modern land back movement. This is a picture from the Black Hills, and folks may be familiar with the conflict that arose there. Of course, long-standing conflict over the Black Hills, many chapters of that story, but maybe most recently in 2020 when then President Trump held a huge July 4th rally with fireworks at Mount Rushmore to celebrate America's birthday. And the tribes of the region were not happy about that for obvious reason. And part of what came out of that conflict and those protests was sort of at least a website and organization dedicated to land back efforts. And it's one of many, and I think it's reflective of a much broader social movement. But for folks who are now familiar with hashtag land back, much of the sort of expansion of those efforts came out of this conflict after 2020 at the Black Hills. And I think that represents sort of the modern social dynamic around land back and its encapsulation of a lot of this historical injustice and modern efforts by tribal nations and really indigenous peoples worldwide to address and overcome those historical injustices as a measure of restorative justice, but also I think as a measure of current sovereign interests on their part to, as I said, restore not just land and property interests as we think about them, even within the American legal system, but all of the cultural, historical, community benefits that come along with the restoration of those connections. So that brings us to thinking then about what this looks like across the country. And this is one representation of land in the United States. These are federal public lands across the country managed by various agencies, which you can see there at the bottom. And consistent, I think, and following on the sort of rise of the land back movement as a social media message, as a social movement, there have been some attention paid, I think, to the possibility of addressing the return, say, of national parks to tribes. This was sort of a eye-grabbing headline from an article in The Atlantic by David Truer about returning the national parks. Now, to his credit, I will say David Truer said, look, I'm just an author and creator. I'm not a lawyer. I don't know how this is going to work, but I'm going to put this idea out there and let you all figure it out, right? And that really is the challenge, I think. What are the ways in which the law and policy, particularly the framework of federal Indian law or the broader framework of the American legal system, enable, authorize, create pathways to securing land back, both in sort of the physical form, but also the broader kind of cultural, social dynamic around land back. And that's really what the rest of I'm going to talk about is. How do we operationalize this movement within the legal framework? Well, when it comes to public lands, folks may be familiar with President Nixon's sort of famous effort in 1970, the return of Blue Lake to the Taos Pueblo. A few co-authors and I, a couple of years ago, put a piece together called Some Land Back, sort of, which was clearly cheekily titled to assess and really try to capture the 50 years of congressionally authorized returns of federal public lands to tribes. And from 1970, this return of the Blue Lake to the Taos Pueblo, to 2020 and the return of the National Bison Range to the Confederated Salish and Kootenai tribes of Montana, there are 44 instances of congressionally approved returns of federal public lands to tribal nations. Now, across those instances, each one is sort of its own situation, its own dynamic. Certainly different issues permeate all of those 44 examples. But there are still some, I think, cross-cutting themes that came up in our assessment of those congressionally authorized transactions. And one of those is that each one of them took a unique blend of sort of political interest to get things moved through Congress. There were certainly restrictions. It wasn't just an outright transfer to the tribe of these lands sort of without strings attached. Many of them came with restrictions on continuing public use or the protection, for example, of Blue Lake wilderness areas and how the tribe would manage them. And all of them were transfers to tribal trust status, so still owned by the United States in trust for the benefit of those tribes, which comes with its own unique blend of tribal federal relationships, federal oversight, et cetera. So while I think 44 transfers over the course of a half century is a significant sort of landmark to think about, not quite one a year, and we can talk about whether that is sufficient in this context. You can see, at least in our view, how there really wasn't, I think, a movement afoot in terms of significant congressional action in terms of the return of federal public lands to tribes. And this is some of the ways in which we kind of summed up or assessed those transfers. Cautious corrective actions taken on a case-by-case basis, successful only where political winds aligned. And I think that continues to be the case both in terms of like tribal advocacy and legislative lobbying for some of these returns and the broader efforts of success in terms of that return. So is it the case that because Truer said return the national parks to tribes, Congress is going to pass a bill tomorrow to do all that? I doubt that very much, but there may be instances in which these sort of mix of ingredients align for that to happen in particular places. Now, I will say before we move on to talk a little bit about co-stewardship, there are some authorities in existing law that authorize agencies to consider transfers, exchanges, et cetera. And so separate and apart from sort of specific congressional authority for transfers, there are some agency authorized transfers that may also be available, but usually those depend, again, on specific scenarios. It may not require the political will, but certainly some unique circumstances to encourage or enable or have some leverage to have those agencies transfer lands as well. So short of transfer, I think a lot of folks have talked about in the public land space, tribal co-management, and it certainly has been a priority of the current administration in terms of policy directives. And it really reflects and builds on a longer legal framework around the federal government's trust obligations and responsibilities to tribes, treaty obligations, of course, and some prior and historic statutory obligations, say under the National Historic Preservation Act and consultation there, or executive orders around consultation and agency directives. But those have really crystallized in the last few years into a series of agency guidance policies, both from Secretaries of Interior and Agriculture, as well as their agencies, the major sort of federal public land agencies, that really push for a more active collaborative arrangement, co-stewardship or co-management of federal public lands engaged with tribal partners. And most sort of relevant is Secretarial Order 3403. This is sort of the marching order of that secretarial order. All of the land management agencies within Interior and the Department of Agriculture, and after 22, the Department of Commerce, which includes NOAA, for example, or National Marine Fisheries Service, were aimed or charged with endeavoring to engage in co-stewardship of federal lands and waters, really trying to build a much more collaborative approach and tribal engaged approach to the priorities by which those federal land management agencies carry out their statutory mission for management of the nation's resources. I will also say in this order, is a section on tribal stewardship. And the order encourages and recognizes that on the part of the federal government, the departments will have a policy to restore tribal homelands to tribal ownership. Now, as I read it, at least, it is primarily focused on the restoration of on-reservation interests, not so much the restoration of off-reservation public land interests. But I think it also represents the commitment or a recognition on the part of these agencies that Landback, or the restoration, the sort of reclaiming of tribal homelands, is not just about co-stewardship, but also about tribal stewardship of those lands and resources. And that really implicates, and the secretarial order itself talks about the federal fee to trust process, which in terms of like mechanics and the structure of land back on reservation, especially, this is how it happens, right? Tribes reacquiring interest, fee interest, usually in lands within their reservation, and then the Secretary of the Interior transferring those lands to trust. At least for most tribal organizations, that authority for the secretary comes under the Indian Reorganization Act. There have certainly been issues there in terms of recently recognized tribes, and I know things here are uniquely situated in that regard. But as it relates to the transfer on reservation primarily of those tribal lands into trust for the benefit of the tribe, this really is the sort of legal and policy and regulatory structure for accentuating and actually actualizing land back for on-reservation acquisition. So it's an important part and has been sort of buoyed by efforts of the federal government, particularly in the settlement of the Cobell litigation, funding for the federal government to buy back fractionated interests across tribal reservations. And that effort, which just concluded last year, you can see from the final report last December, all of the places in which the federal buyback program made voluntary offers to individual allotment interest holders as a way to reconsolidate back into trust land holdings for the benefit of the tribe, many of those highly fractionated allotment interests. Now, I will say, and we have a slide at the end that sort of talks about, well, what now in light of a new administration coming in? I will say one thing that the new administration, well, I shouldn't say the new administration, it's actually in Project 2025. To what extent that reflects priorities of the new administration, TBD, a couple of different things. But I will say refunding the tribal land buyback program was specifically mentioned as a priority for the new administration in Project 2025, for whatever that's worth. So one note there for folks to think about as we go forward. Last but not least, I just want to talk a little bit more broadly about other strategies and issues, particularly as a way to set up thinking about private law and the role of land trusts and conservation easements as we come a little bit closer to here for the rest of our discussion. And I just wanted to note, there's been some recent press, some journalists have uncovered and really focused in on the ownership of state trust lands, or the connection between state interests, particularly land grant universities in the West, and the taking of tribal lands. I don't know if folks are familiar with some of that work that's been published by Grist and High Country News. This piece most recently focused on the presence of those state trust lands within reservation boundaries and the amount of resources and money and decisions that benefit state budgets from the development of those on-reservation state trust lands. And I raise this both because it's relevant in terms of thinking about land back. It's also relevant in terms of like state tribal relations and the benefits to state budgets from tribal resources. But it's also tied directly to the Flathead Reservation that we saw earlier in Montana. And this is, I think, one illustration of another strategy around land back approaches that was recently enacted, and I think presents some pretty perhaps exciting or at least interesting ways to think about opportunities for furthering this movement. You can see a couple of things about this map from the Flathead Reservation. One is this big purple blob right in the middle. That's the National Bison Range, which was carved out of the heart of the reservation in 1906 when the reservation was open for allotment. It was also incredibly galling to the Confederated Salish and Kootenai tribes, who had and really were the ones responsible for ensuring that wild bison remained alive in the continent by saving a herd and moving it to protect it, only to have the United States then say, and we're going to create a national bison range right in the heart of your reservation that we are going to manage to make sure those bison stay alive. The tribes had long made it a priority to return the National Bison Range, and they'd pursued a whole number of strategies to succeed in taking over management and control, reestablishing ownership, many of which had run into various roadblocks. And there's a long and winding story here that we don't have time for. However, in settling their water rights, which was also a long and winding process, they were able to secure through the passage of the Montana Water Rights Protection Act, which finalized the terms of their water rights agreement with the state of Montana and the United States, the return of the National Bison Range in trust to the tribe. So now this map is outdated. That blob is no longer purple, it is bright green. And that is trust lands held by the United States for the benefit of the tribe, and the Confederated Salish and Kootenai tribes are managing the National Bison Range, not just on their behalf, but on behalf of all of us. And I will say, in the years since they've taken it over, doing a heck of a job. Probably much better than the United States Fish and Wildlife Service had been doing prior to that. But also part of this legislation, which I think is worth thinking about, called for, you see, mentioned all of those state trust land blocks that are scattered throughout the reservation. Those lands were granted to the state of Montana, not upon statehood, which was the usual way in which state trust lands were granted to Western states, but rather because this was a reserved area by treaty for the tribe at the time of Montana statehood, they were granted to the state when the reservation was opened up for allotment in the early 1900s. And like the Bison Range, I think had always been a point of friction and disagreement and disgust really from the tribes. So included in this water rights legislation was also a process pursuant to which the United States and the state of Montana can exchange those parcels to restore those parcels back to trust lands, and in exchange for off-reservation federal lands to benefit the state of Montana, which is a pretty innovative way to think about approaching that. But even on top of that, there is, if that exchange does not proceed, and not knowing the political situation in the state of Montana, it's tough to say whether or not they'd be interested in pursuing any of those agreements. The bill also allows for voluntary exchange of non-Indian owned fee properties within the reservation boundaries to secure the total amount of acreage that would otherwise be covered by those state trust lands. It's about 40,000 acres or so of the reservation. So it's not just land back in terms of state trust lands, but providing a way for non-Indian citizens owning lands on the reservation to restore those lands to tribal ownership through exchange with the federal government, which is a pretty unique, I think, and innovative solution, or at least approach to thinking about reconsolidating some of these tribal land bases here in Montana. So certainly a number of other ways and sort of place by place specific approaches, state level approaches to land back, both in California in particular, but elsewhere across the country. I think those are being pursued. And as we'll hear, I think the private law aspects in terms of land trust, conservation easements, the ways in which private parties and conservation groups and tribes may be able to come together to secure these goals are also an important strategy as well. I mentioned sort of what now. I just threw this in because it was recent-ish from last week. But I think it raises some really complicated questions thinking about what is coming in terms of priorities of the new administration, especially in light of the history around public lands, privatization, states' rights movements, et cetera. But there may be ways in which some of these ideas align. Also, I think worth thinking about threats there as well. Last thing I wanted to leave you with was this. That's Chief Mountain in the background. That's in Glacier National Park in Montana. And the story of Glacier and the story of the taking of that area from the Blackfeet Nation is one that tracks with the historical legacies that we've talked about. That still is a national park. It is still not in tribal ownership and control. However, last summer, the Blackfeet Nation reintroduced a free roaming bison herd on their reservation that without fences will be traveling into Glacier National Park and roaming territories they long roamed. These are the bison there on the Blackfeet Reservation right there in front of Chief Mountain. It's not land back, right? In the purest sense of the word, that lands are still controlled by the United States and still subject to the policies of the United States, not the Blackfeet tribe. But certainly I think the return of the bison has much deeper meaning for the Blackfeet people. And especially now and going forward, there will be bison roaming those areas, even if the land isn't back in Blackfeet control. So I think that, as much as anything, is the power of and potential of land back here. So thank you for your time. I look forward to questions and the further discussion.
Thank you, Monte. I'd like to now invite up Dr. Suzanne Greenlaw, who's a citizen of the Holton Band of Maliseet Indians, and who conducted her doctoral research here at the University of Maine. And among other things, that research has supported the inclusion of Wabanaki indigenous knowledge in conservation and an emergent shared governance approach for some of those resources in Acadia National Park. So, Dr. Greenlaw.
Thank you, everybody. I'm gonna pull this down. Maybe it's for tall people, I guess. Yeah, I'm a trained ecologist, and there's a part of me that's nervous giving a presentation in a law school. It's not my typical audience. I'm also going to hold up my presentation because this is a new presentation and I don't want to miss anything. Do I have enough? Oh, it's going to go. Okay, cool. But I do see a lot of friends in the audience, and it's really wonderful to see everybody here. So thank you so much. So I'll talk a little bit about the introduction I had as well. In my work itself is working under National Park Service federal rule changes to sort of open up and expand what Indigenous or Wabanaki caretaking roles can be in those spaces, as well as create sort of foundation for a more equitable co-stewardship approach in conservation lands often. But today I'm going to actually introduce a little bit about the Wabanaki Commission on Land and Stewardship. So I work for the commission in partnership with Dr. Darren Ranko and Dr. Tony Sutton. And the commission itself is it's an organization supported by tribal government, where our 2 people from each tribal government are appointed as an advisory board that helps us move forward with land return work. I'm going to give a little bit of background introduction. Is comprised of 4 federally recognized nations and 5 nations in total. Our traditional territories span from southern New England area up to Nova Scotia and New Brunswick and Quebec. But our realities are today is that we have a much smaller land base, but we hold, and our reservations are much smaller. So the initial journey of the Wabanaki Commission first started with First Light Learning Journey, which many of you are aware of, I'm assuming, and had heard about in supporting this presentation and this talk. And this was the goal to build new partnerships for land return and rematriation. Right? Oftentimes in the past, at least in this area, conservation organizations were often in opposition to tribal interest. Right? We have a lot of stories in our nations where the Trust for Public Land or the Nature Conservancy in particular, all of these organizations oftentimes restricted our use and value systems within their landscape. So this was a movement to kind of start to learn from each other, to change direction and to work together for shared goals. And it first started in 2017, which was a collaboration between conservation organizations and the Confederacy tribes. Right? So this was tribal government. So how do we rebuild Wabanaki stewardship and presence across this landscape with the goal of restoring true prosperity for Wabanaki people and expanding Wabanaki caretaking on landscapes and land return? And this is that's not what that was. This is the cohort of conservation organizations that many of you are here today who work for these organizations that are part of the delegation leadership, which is a closer working group with the commission. The commission works with tribal nations, and we work in partnership in close collaboration with this delegation leadership. And so we still hold these 2 organizations as separate organizations, but that ones that share similar values, and we work in really close and direct collaboration. Like initially at one point, the idea was that the First Light would just dissolve after the nations have sort of moved forward with land return, and that we would just take over those roles and responsibilities. But our commission, our advisory board, actually wanted to work in collaboration with the delegation, with the First Light, that we felt that people felt that they hold certain roles and responsibilities in land return, and it's important for them to hold those spaces. So this is First Light's mission, is to relearn, recenter, and return. So this being accountable to non-Native organizations to relearn new ways of thinking, but also be reflective and understanding how their roles as conservationists and conservation in general has been a tool of exclusion and sort of enforced Western frameworks within conservation. So that's a role that we don't take on as Native people, right? That's the role for non-Native organizations to teach themselves and their peers this history. And recenter, so commit to Wabanaki-led and community-tested change, and then return land. And return land without cost and restrictions with a fund to help care for it to Wabanaki people. For the commission, we're to improve the health and well-being of people within our nation. To expand access, management, and ownership of lands. We support acquiring lands and sharing and co-managing landscapes. And this is sort of the work that the three of us do as the staff. So we both work with access and expanding out access and conservation lands, as well as shepherding land return work with our organization. And First Light as an organization really helps a lot with that land return work, as well as the conservation organizations, right? Like, we've found in the past that the relationship and the collaboration between a Native and non-Native organizations create certain pathways of land return that are better than just one or the other. And today, this is the 6 completed projects for land return. So I'm just trying to give you a background, the history that land return has happened in 6 projects. They've connected trust lands, returned the stolen island, supported economic growth, securing access to cultural sites. I'm not going to stay here too long. And this is projects in the process. So that's 6 land returns over the past 5 years. It's a slow process, but we have 11 land return projects that are coming up, including the one we're going to talk about later on, for Trust for Public Land with the Wasatakook piece to Penobscot Nation. And so this will nearly double the land holdings for 2 Wabanaki nations in Aroostook County. So our Mi'kmaq and Maliseet nations they hold less land. And so one of our goals is to ensure and understand what are those barriers to land return up north, and to not just ignore or pretend like, or not, ignore those challenges, but actually dive into the challenges, because they're different. They're different challenges for Southern tribes and for Northern tribes. So understand those challenges and do something about it. So that's one of our goals too. That's the background, which we'll talk more about that later. But I sort of also wanted to talk about so restrictions and critiques that are coming up in Landback and land return and rematriation work. Right. So some of the work I do is in National Park Service under a federal rule change for plant gathering. Right. This rule change happened where we thought that we could enter into agreements, or tribes could enter into agreements to actually start gathering and creating co-stewardship or co-management agreements. The same thing with land trust. We work with land trust for increased access. But all of these frameworks, these places require a lot of requirements and restrictions onto our practice, right? So for National Park Service, there's an environmental assessment with a finding of no significant impact that's required. For land trust, they have easements, and those can be really restrictive to our actions and our practices. Or this federal funding that requires sort of an understanding of what is a sustainable harvest limit. Right. We also get asked, where do you want to harvest and what do you want to harvest? That somehow we are to have that understanding before we get to the landscape that we've been denied access to forever. Right. But why? Why do these exist? Why are we having to prove that our knowledge is a sustainable practice? Why are we being regulated and controlled And oftentimes there's a permit system that tells us a limit amount of harvesting can happen. So it's a very sort of scarcity limit approach to our practice. These really kind of go against our traditional practices of land management. And then a recent critique I read about the land return for Trust for Public Land was that it undermines the national park ideas. Instead of giving that land to a National Park Service, giving it to a nation, it undermines the national park idea and the preservation of natural ecology and evolution processes. So it was betraying the public trust. A land return is doing that. This person also identified that privatizing that landscape into forestry would perpetuate extractive behaviors and ruin the ecology of the landscape, right? So the idea that because tribes have forestry departments and uses timber for income, that instantly means that we would move into these extractive practices. Right? And these are things that get pushed onto us all the time and seen as valid, I would say. Oftentimes in these rooms I'm in, other scientists struggle to let go of control, or conservation people, right? It's about control. We wonder, like, why? Why do you need to control that so much? What is it that you hold that is more than what we know? And so when we think about these ideas, we often run up against these stereotypes or tropes and these anthropological fantasies that are projected onto us, right? We often are in a space of dealing with these fantasies that kind of conflict against each other. But so the noble savage, right, is one that we get. So this is the sort of infantile Indian, or the pure Indian that isn't corrupted by whatever modernity brings. I don't really know. And that we have that idea, this mythical Indian, that we wouldn't harm the outdoors of the nature, or the ecological Indian, one that is just living in nature, living in harmony with nature, that that we haphazardly live on the landscape. Biodiversity just exists around us, and that we just eat what we find. Right? These are all sort of ideas that seem silly as I say them out loud, but get brought onto us a lot. For example, in the picture on the right, that's us harvesting birch bark for a canoe, right? Beautiful, amazing, incredible. A question we get asked often is, do you kill a tree? Like, what do you think? Right? Like, that's ridiculous. Yes, we kill a tree. We kill a tree. But it's the idea that if we're killing a tree, we're not Indian. That's the sort of underlying assumptions that get asked in these questions, right? And so we navigate, oftentimes if it's a landowner, we navigate how to respond to that person, because they could deny us access if we break their idea of who we are. Or do we, another one is, how come you use a chainsaw? It's silly, but they get asked to us all the time. And then we have all these jokes. One joke is like, oh, we used to use beavers, but now we can't find any. Like, right? Like, we're just whatever. Or also picking sweetgrass. Do you pick the root? That's what scientists will say to native gatherers. And then we'll tell them that that's inappropriate. Picking by the root is not good for the grass. Why is it that they have more authority? They hold more authority in our society for knowledge over people who've been practicing it for 30 or 40 years. And then also this role of art and sort of perpetuating these myths, right? So Andrea Baer Nicholas wrote a paper about the role of art within the 1800s and actually like perpetuating these fantasies while it actually hid the sort of, it hid the cultural genocide that was occurring, right? The dispossession of land and the land theft. So all of those images that you often see by artists of that time frame, was actually hiding the truth. And when she supported and looked at the actual writings where Native people were petitioning the states to stop this from happening and the horrors that were happening, was not being seen, right? And Donna Loring wrote a paper, I wrote it down so I wouldn't forget. One Nation Under Fraud, where she quoted the fabrication of the pauper narrative, right? So the state of Maine perpetuated the idea of the pauper narrative so they can continue to steal and maintain Native people in a controlled position, where our own ability to extend out our technologies, our practices was suppressed, right? And so, or oppressed onto us. And so the idea of the pauper is also something we get into here. Another comment we get is when we're at a fair or something, people see the practice of black ash, we also will be told, there's a faster way to do that. By a non-Native person. There's a faster way to do it. You don't have to do it that way. That looks really hard. So they're really kind of perpetuating this idea or pushing this idea that we don't understand a better way to do something, right? It's like that there's a faster way. If we mechanize it differently, if we put it in production line, we could do it better. So, but what's not included in these stereotypes? Do we talk about Native people as innovators or Native people as entrepreneurs, as scientists? Hold on this one. So I kind of always like this idea of what Wabanaki technology do we see today? Our knowledge is that we see today that are actually thriving businesses around us. I don't know if any of you have any ideas or suggestions. Or if a painting like this might help, right? This was painted in the 1895 of a canoe in Katahdin near Millinocket Camp, right? So what businesses today are thriving are built off this idea. This is Wabanaki knowledge and technology, right? Canoes, Old Town Canoe. It's a thriving business that is built from Wabanaki technology. And I'm not trying to besmirch any of these businesses, right? This is not what that's about. It's more about the erasure of knowledge and technology or indigenous knowledge and technology that maintains the idea of the pauper or the ecological Indian, right? LL Bean, right? That is indigenous knowledge of the guide. When we think about Thoreau as the main hero sometimes, as the explorer, he was being completely guided by Native people the whole time. He was not exploring on his own. That's all Wabanaki knowledge of place names, location, travel routes, the canoe itself, how to care for yourself, what's in the landscape and what you see around you. Also Burt's Bees, right? When you think about that creation of the farmers getting an understanding information from the Farmer's Almanac of medicinal plant knowledge, that's also Wabanaki knowledge. So we have businesses around us that are built from Native technology and knowledges, but we don't say it that way, right? There's obscuring it and erasing those kind of knowledge bases. But we do have examples today of what sort of a Wabanaki framework of land care and land stewarding, of generational thinking, relational aspects, and income and economies that are all around us. Right? When we see this basket, which many of you know, Jeremy Frey, he's a well-known Wabanaki or Passamaquoddy basket maker. Right? He just had a solo show at Portland Museum of Art, is traveling across the nation. He is one of the most well-known Wabanaki basket makers. When you see them in museums, do you understand the sort of depth of what he's doing? Do you see him as just an artist? Or is he actually a land manager? Can you be both? Right? For Native people, it's all in the same. Right? So this is the process of harvesting a black ash that basket was made from. And so what we do is we harvest from the same location year after year after year. And through that, we are maintaining the ecological value system, or whatever values you want to say, the ecological services, the biodiversity, all of them are ways of understanding the health of a landscape, right? And all of those exist in what we do. We maintain the system it's a river floodplain system. So you can see how farmers value these floodplains that hold soil in and sort of clean the water as it runs through. The biodiversity in these areas are extremely high. These are rich mesic forest areas. And the plants that exist here are considered, they're not rare plants, but they're considered valuable plant systems. And it's through our caretaking roles that this system exists in this way. right? We are intentionally harvesting trees that keep the future stand thriving. So these are examples of our economies and our values, all together in one system. Our economies are not in opposition to the caretaking roles we hold for landscape. So that previous critique of that this is against the public good and this won't be good for biodiversity is just not true. It's sort of built in these ideas or these misconceptions, I think, of Native people. And so this is a framework I created for a project that we did for Acadia National Park. We were charged with helping to get an EA passed for sweetgrass gathering in Acadia National Park. And there was a lot of fear in this position of going to a federal rule and trying to go through an EA process that we would be shut down, that whoever determined those findings would not see Native knowledge as a sustainable practice, right? That's a difficult position to be put in, but it also could mean that we would open up access to cultural materials that people are being denied access to. So in our project, we decided to really highlight the more framework knowledge of sweetgrass instead of the plants returning, how many numbers returned or what is the stem count density, right? And so what we did was talked about the tangible results that we see, right? We all see the biodiversity. Those are noticeable things. But that's not always what governs our decision-making, right? What governs our decision-making is these collective community responsibilities that we hold to both landscape and our community, as well as our both individual value systems to the individual grass and our experiences. It's always so interesting. We also did this framework because while conservationists or these policies often want to control what we do, they also want to take our data and mimic what we do, right? So we get told, just tell us what you do and we'll do it for you, right? Like without really any sort of understanding what they're saying is pretty insulting. Like, how can you do what we do? How can you employ all of these cultural value systems within your management strategies, right? So, so there's multiple examples, I guess, of indigenous enterprises and entities. There's the Menominee tribal timber enterprise, where they have a working timber production and forest, as well as biodiversity is really high and biomass is really high, right? There are examples you can find throughout that shows the value systems of indigenous relationalities and accountabilities and responsibilities with economies. So oftentimes those arguments and those critiques fall flat for me because I don't understand where these people are coming from. They obviously have this sort of education system that's built on these misconceptions of Native people. I wasn't able to get this slide ready in time, but Chuck Loring, who is the Penobscot Natural Resource Director, shared with me a map that showed that within the state of Maine, the Penobscot tribal forest lands, they show the biomass indicators, right? And then when the biomass, the Penobscot tribal forest lands had a high rate of biomass in comparison to the other forest lands next to it. So when we think about the Trust for Public Land returning land to Penobscot Nation, and is that for the public good? Like, yes, right? How is that not for the public good? The idea that more examples of our value systems with timber production, I think could show different ways of doing things, where we just don't see cutting as extraction. But sustainable forestry with indigenous value systems and our technologies and economies growing outward are for the public good. That's it.
Thank you, Dr. Greenlaw. I'd now like to invite up Shelby Thames from the Trust for Public Land. This part of the conversation, we're going to focus specifically on one ongoing Landback transaction. And I'll let you introduce that, Shelby.
Why don't I just sit?
Yeah, that's fine to sit there and do it. I'm going to sit down here.
So thank you for having me here. And I'm
blushing a little bit to be on this illustrious panel here and with you at Maine Law. I'd love to give just a very short thumbnail of a project and, more importantly, a partnership that we've kind of touched on, and Suzanne in particular. And then I think we're going to have a lot of time for Q&A. But I think the opportunity to talk about this project was to really funnel down into one particular illustrative example happening here in Maine of the opportunity of this kind of work, both pre-existing and moving forward. So I serve as our vice president for the New England region. I like to acknowledge that I have colonialism actually in my job title. And I actually am here today because the two forces behind both Trust for Public Land and Penobscot Nation couldn't be here today, but Betsy Cook, our Maine State Director for Trust for Public Land, and Chuck Loring, the Director of the Natural Resources Department with Penobscot Nation, are really working with their teams, our teams, to advance a really visionary, I think, project in the Katahdin region of Maine. I did want to touch briefly on Trust for Public Land's history, though, in the context of some of what Suzanne shared in particular. We are a national parks and conservation organization, and I actually put our mission statement up here on a slide because it actually illustrates a number of the opportunities and reinventions, I think, underway in the conservation movement, and part of why we feel particularly comfortable in the space that we're in advancing this particular Landback project. So we create parks and protect land for people, ensuring healthy, livable communities for generations to come. So we are anchored by people and community in our mission. Parks and land protection is an avenue of being in service to community. That being said, the word protecting land, what does that mean? And I think that's where the evolution and unfolding that this conversation is really speaking to comes alive as well. So we can go to the next slide. So the project that we have been working on in partnership with Penobscot Nation is termed WSADC. This translates to East Branch of the Penobscot River. And this is an effort to restore nearly 30,000 acres to Penobscot Nation. And based on kind of our research and the manner in which the transfer is being envisioned, and the return of this land is being envisioned, that this is the largest voluntary, private return of land with a US-based nonprofit and tribal nation. So the map here shows the land in question. And as Suzanne anchored us in Wabanaki Nation's historical and ancestral homelands in a map she showed, another version of looking at this map is that maybe a traditional kind of conservation orientation or outdoor recreation orientation, which is the Baxter State Park, Katahdin Woods and Waters National Monument, and other significant conservation or public lands. So you see here Katahdin, terminus of the Appalachian Trail, and the lands in orange, I guess that's orange, are the roughly 30,000 acres that we're working on in partnership with Penobscot Nation. So the short thumbnail on the history of the very recent history of this land is that in late 2022, we at Trust for Public Land became aware that a timber investment management organization that had owned the land for a period of maybe 8 to 10 years was going to be kind of running an auction or sale process on the property, and we assembled the resources to acquire the land on a kind of a temporary basis based on some really strong intrinsics of both the property offering access, southern access into the relatively recently established national monument, and being in the heart of Penobscot homelands. And so fast forward to November of 2023, we kind of went public in partnership with Penobscot Nation about an intention and a vision to return this land, and in doing so, raising a $32 million capital campaign, essentially. We have secured the property with some interim financial resources that need to be repaid. So one thing I want to mention about that is that if any of you have been involved in a capital campaign of any sort, you're usually quiet for a period of years or months while you're building towards getting to, maybe within 25% of your goal, and then you go public. Right now, we are $7 million into a $25 million campaign to return the land. And we're doing this in full joint partnership with Penobscot Nation. And we've inverted the sort of traditional approach around a capital campaign, which is to be transparent from the start about what this vision is. If we were quiet for a long period of time building up to this, I'm not sure we could accomplish it. And it's really exciting and important to tell the story every step along the way of what this is taking. I do also want to just mention, and sort of closing of the background here, is that we are, as a function of our involvement in First Light Learning Journey and our organizational commitment and ongoing understanding and learning around how we do this work being as important as that we do it, our deference is to understanding what type of deed restrictions Penobscot Nation finds compatible with their long-term ownership. That removes a number of traditional tools of advancing that fundraising campaign, and particularly from public sources that traditionally have been used to kind of fund conservation projects. And so we actually have $25 million of public funding pending for this project right now, principally from the Inflation Reduction Act. So you can imagine we're feeling pretty motivated and excited about the opportunities, but also experiencing a bit of trepidation about what the transition and administration may do to Inflation Reduction Act dollars. We believe that if all of that comes in, all of those sources of public support would be compatible with Penobscot Nation's ongoing assertion of their political independence, sovereignty, and self-determination. So I'm thrilled to be here on behalf of my colleagues, and excited to share more about the project if folks have questions, and how it illustrates some parts of what Suzanne and Monte spoke to.
Thank you so much. I'm going to take the moderator's prerogative and ask the first question sort of to all of you is if you could maybe speak a little bit more to those sort of complications in negotiation, in particular in these private transactions. Shelby was alluding to it a little bit. Where are some of the sticking points with respect to deed restrictions or other limitations on the property that might be being transferred?
I can take a stab at that and pass it on. So, I think that there have been fewer sticking points in terms of the vision setting for what the plans are, in part because Trust for Public Land, as the current temporary owner of this property, has a deeper and fuller understanding of what the drivers are behind not wanting to encumber the property or sever certain property interests, third party. Now I'll get into my legal terminology. Third party enforced, development restriction on development rights, which is what a conservation easement is, like from the get-go. I will say that we've been working we were established in the early 70s. We've had a native lands program for many years that was started in the mid 90s. In fact, Chuck Sams, who was the current director of the National Park Service, held the role of directing that program with us in the mid 90s. It's now led by my colleague, Ken Lucero. We've done projects totaling or partnerships, I should say, totaling about 200,000 acres of land. But this is probably one of the first projects we've done that contemplates it happening without restriction. And that comes less from an organizational bylaw or change or significant outlook change. I think a lot of it is driven by kind of the practicality. How are you going to fund this thing? And that's what's really what we're really trying to rethink. I will say there are, Suzanne, you referenced some of the kind of public criticisms that have been, that article was kind of an extreme embodiment of what we've encountered in more kind of polite contexts. And I think that, I think that there is an ongoing learning across the board within, both staff of different organizations and philanthropic community to understand what does conservation mean, and how are there many different ways that it could look.
I'll just add a little bit on the bigger picture, not specific to this transaction. There are differences, for example, in terms of state restrictions or state laws that may be applicable to particular conservation easement transactions. In some states, for example, tribes or tribal nations aren't eligible as easement holders in those regimes. There are also, at least in the discussions that I've been involved with, a lot of discussion around, well, what about a tribal government possessing sovereign immunity, and how does that fit into the conservation easement framework? What are the concerns about violations of the easement or enforcement? And so I think the nuances and details, as with this particular project, depend to great degree. And I recognize as a law professor, I'm saying it depends. I know that's really strange, but a great degree on the specifics of the transaction and the nature of the interests at stake. And it could be sort of within a traditional conservation easement framework, or maybe will require some more creativity as in this particular situation. But
I would add one other piece, which is sort of the follow-on steps of this. Even if, if and when we get to a point of being in a position to convey the fee title interest to Penobscot Nation, their intent is to enroll the property in the trust lands status, and there may be continued complexity and sort of a journey that you spoke to, Professor Mills, in that kind of step of this project's journey.
Do we have any questions from the room? I think we can. Oh, yeah, go ahead.
This is so direct related. My name is Sarah Robinson. I work at the Somali Bantu Community Association, and we are in a land transition process for 104-acre property in Wales. And our biggest sticking point was we found out from Lakota that during a session that if we put an easement on our property, we could not then potentially have an Indigenous partner we could potentially give the land to if we ever gave it up, or we just thought we're not doing that because traditionally Somali Bantu people were also, their land was taken away. So they said, this is really important for us as an org. And I don't know how many people know this, but the Farm Service Agency has a huge land access grant that's just been released. A lot of nonprofit organizations, BIPOC organizations, including ours, are trying to help BIPOC folks access land. And I brought up, no one had heard of this, about the issue with the easements. And what we really need is a lawyer who knows something about multiple states and easements, to sort of talk through this process to make sure that anybody involved in this grant really isn't not thinking about this as part of their process, because it just started, a lot of them in November. So I feel like this is a really amazing point to sort of make sure this discussion is happening now, and an opportunity to have a lot of Landback happen if we're really thoughtful about it. So anybody who has a lawyer connection who can help us with this process would be amazing.
Thank you for that. Yeah.
Yeah, the 1980 Land Claims Act, which really treats Maine tribes significantly inferior to 49 other states. How does that play into this whole process? I'm assuming not well, but maybe that's an assumption I shouldn't make. And to the people particularly working within Maine, I think a lot of us thought when Paul LePage left office that the new governor was going to be much more friendly to natives. And it seems like she spent a lot of time fighting with her own party in the legislature against the interests of Native Americans. And I've never really understood that. And I'm interested in some perspective maybe on that, because I have a feeling that factors into what you're trying to do here.
Well, let's focus on the change, the difference in legal status, because I think Monte might be able to speak to that a little bit, because it is very different here in Maine than it is across the country.
Yeah, just very briefly, not being as familiar with the unique situation here, I will say the 1980 Settlement Act does include some provisions. I mentioned, for example, the secretarial order about tribal stewardship and the interests of federal agencies in terms of transferring lands to tribes and supporting that. There was a report prepared by the Department of Interior Solicitor's Office about authorities to do that, and recognizing some specific authorities for transfer, including a provision of the 1980 Settlement Act that allows for transfer of some lands to tribes here in Maine as a part of that settlement. However, subject to some pretty specific restrictions around how that can happen and what that process is. So I know about that much about in answer to your question, but I do think those, and to some degree, although the situation here is unique and different, I think it highlights also the unique status and differences that may exist elsewhere too. So I think it's not, even though it is unique, the uniqueness isn't unique in terms of the other uniqueness that is occurring across the country. And another place I think where this is particularly different, but also in some ways the same, are deed trust transfers up in Alaska as well. So just to say, that's about the extent of my familiarity with the connection, but I'm sure there are other folks and experts in the room who have much more sense of the particular status here.
And I have a couple questions from the internet, so I'm going to take them as well, not to forget everyone who's watching on Zoom. This is a question primarily for Dr. Greenlaw and Shelby as well. What are the processes, the typical processes, what might there be for evaluating and identifying parcels of land that might be good candidates to do these kind of transactions on? Like, how did we pick this spot and how might you pick other spots in Maine?
I mean, a lot of that work is the response or back onto the tribal nations, right? So these are for individual nations, and we have 4 federally recognized nations that are part of land return, and the commission doesn't do the work to identify the lands. What happens, and what's been happening is maybe we've had more of a passive role where conservation organizations have brought land return to us, or private citizens have brought land opportunities to the commission. And that's been a little bit of a challenge in the sense that we don't know, it kind of gets held up in the air a little bit around, is this a land base that we can have connection with? We don't want to be just landholders. That's not what the Wabanaki Commission is created for, right? These are land returns for our tribal nations. So to move that through tribal government takes time for them to understand and prioritize. And so we are working to flip that approach where each nation will start to work through what are their priorities or what sort of interests do they have, and we can identify lands to work that, we can be more active in the identify landscapes to return.
I think we have time for maybe one more question Yeah. You can, in the front. Yes.
I have not as much as a question, but an appreciation for what you're doing when you presented it. And my intent to be following up from each of you on different parts of it. My connection with Landback goes back to years prior to Passamaquoddy versus Morton, when I followed with Tom Tureen his development and evolution of it. And I was privileged to, as a journalist, to break the story when Morton was handed down, resulting in a lot of communication and education about Landback, including the legislature using my work to, I'm sorry, I have a hearing deficit. I can either speak too loud or too soft. Appreciate that. To educate the legislature on what on earth was going on. So that's how I started with Landback, and I've never been able to let it go. Present, I'm a prospective landowner and member of the land trust for Penobscot County, Penobscot Woods and Waters, to trustees. And the land I'm donating, and I'm feeling connections here that I want to explore. I had challenged them to accept the land donation with a commitment to the entire watershed of that brook that drains it. Small, neat, 3,500 acre watershed. And so I would like to see what I could tie in, especially with you, Dr. Gardner, but following up on each of you. So I just appreciate the opportunities that have sprung up from this. Just a one remark on the law. I find in communicating with non-Indians in Maine about Landback is communicating about sovereignty and what that means. And an obstacle for me in that is the way that sovereignty is being talked about, leaving out in an advocacy way, legitimate, important. I do it too. But leaving out the fact of whatever tribal sovereignty is, the plenary power of Congress. And that's very confusing for people because what they hear is with sovereignty is, oh, totally separate.
Thank you.
I'd love to work on that. Thank you for your time.
Thank you so much. So I just want to, in closing, say a couple things, and that was a great segue. One is in terms of education about sovereignty here in Maine, that we've done, this is the fourth of these lectures, and that was very much the topic in earlier years. And I encourage you to go out and find the video recordings of those earlier lectures and to share them. On the topic of land back transactions and private land trusts here in the state of Maine, I know many in the room are involved with land trusts, either as private citizens and donors or working with land trusts. And I encourage you, if you haven't thought about these issues, to raise them with your land trust and think about ways that you can get involved in this kind of an effort. And then lastly, that I'd like again to thank all of you for coming, and for those of you who supported the lecture financially, and encourage you to support this lecture going forward and Maine law more broadly. This kind of programming is really important to the education of our legal community, to young lawyers, so they can answer some of the questions that you all are asking when you ask them to land trusts. So thank you very much for that support, and I hope you have a nice day. Thank you.